Good afternoon, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Lope TV. Before we begin, if you don't mind, please go ahead and hit that like button, that subscription button, and turn that notification bell on. I'll give y'all a few seconds to do that. All right, so I'm going to go ahead and jump right into this, man. This will be a series of videos of probably maybe about 5. I'm going to try to do it, keep it at 5, okay? But in these videos, I'm going to show you cases from all over this country holding that the people of this country are sovereign. In other words, I'm going to show you all of the so-called state courts, Supreme Courts, if I'm not mistaken, of each state, holding that the people are sovereign, because I'm tired of seeing these sovereign citizen videos where the YouTubers who are just making fun of people in the videos who really don't know what they're doing. I'm just really tired of seeing that. So we're going to go ahead and get started. But first, give me 1 second, y'all. I'll be right back.
We're about to celebrate the 250th anniversary of the Declaration of Independence. And you look at the promises in the Declaration, and they're so profound, right? We are all created equal. We have inalienable rights. They don't come from government. They belong to each of us. And government derives its just powers from the consent of the governed. We are the sovereign of this country, we the people. Those are profound promises. And we all want those promises to be realized more and more over time. And the questions I'm asking through the book, really through the stories of the people to whom it's dedicated, how are we doing? That's kind of our report card, that those 3 promises in the Declaration. How are we scoring?
All right, I'm going to stop it right there. So I want to show y'all something, you know. I want to show y'all something. I've already done it in one of my videos, but I'm going to do it again. This is, okay, I'm going to read y'all an excerpt for something. I'll try to keep this video as short as I possibly can. Try to keep it under 30 minutes. Let me give you the case citation. This is a Nebraska Supreme Court case. Let me see if I can give y'all the case citation. It should be up here somewhere. Right here. So it is 55 Nebraska 480. There we go. That's the case citation if you want to read it. So I'm going to go down. I'm going to show y'all something. The federal Constitution guarantees to every state in the Union a Republican form of government, not a democracy. A state with a different form of government could not be admitted. The right of local self-government is an essential element of Republican government. Therefore, it is not within the power of the legislature to prevent the people of the city of Omaha from selecting their own officers. Let's see. Go down a little bit more. The statute interfering with the right of local self-government in the city of Omaha is a violation of the following provision of the federal Constitution. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Local self-government is an inalienable right, whether wholly written, partially reserved, or wholly reserved. Saying it doesn't matter if it's in the, they're saying it doesn't matter if it was actually written in the Constitution. It's implied. It can be implied. That's what they're saying. Right here. This is the most important part that I want to talk about right here. At the time of the Declaration of Independence, the town and the county were the only municipalities, not the city, known to our political history, and they possessed complete powers of government in all local matters, legislative as well as executive. Any diminution of the original complete governmental powers of the towns or cities arose slowly from the voluntary surrender of their rights for the purpose of combining into a democracy, they voluntarily surrendered their rights for the purpose of combining under a common government, that's a democracy, which should be so constituted as to act as an agent for all in all matters of common interest. Powers not surrendered in the written constitutions remain with the people. The right of local self-government is the possession of the individualized citizen. It does not belong to the states, nor the towns, counties, or cities, but to the men who inhabit, but to the men who inhabit them. So I want y'all to pay attention to this. The right of local self-government. This does not just mean a political subdivision. This means you govern yourself on your own property, free from government, right to privacy. That's what it sounds like to me. Now, if you think I'm reaching with that, let me know. But that's what it sounds like to me. That's a reasonable conclusion. And that's what it sounds like to me. Although that may not be how they are, in other words, the context in which it is being used in here. But it sounds like it to me. So that's why I wanted to point that out. Let me get back to it. The right of local self-government is the possession of the individual citizen. It does not belong to the states, nor the towns, counties, nor cities, but to the men who inhabit them, in which respect it differs from the similar right exercised by the European municipalities prior to the Revolution. It is an inherent right. Okay, well, if it's an inherent right, then you can do this by yourself on your own land, on your own property. It's fundamental right. It is conferred by no sovereign power, and no sovereign power can take it away. So it must be given by God. It's an inherent right. It is a common and equal right. It belongs to every American citizen, and a state constitution which should preserve it to some of its citizens and take it away from others would not in that respect conform to the requirements of a republican form of government. I'm gonna stop right there because again, I don't want to make this video too long. But I want y'all to point this out. Y'all see what they say when they're citing Cooley right here, where it says Cooley constitutional limitations. And this case is from 1898. There are cases older than this that references Cooley. Cooley know what he's talking about. All right, so let's go to the cases that I want to point out. All right. The first thing I want to point out here is this is a principle. I don't care if it's still in the Georgia Constitution or it's not. All right. I don't care if it's in your state constitution or not. This is a principle, which means if it's in your state constitution or if it's not in your state constitution, that's irrelevant because you still can do it. So let me read y'all this. Because we have a compact, a contract, an agreement, with the government. We'll obey you in exchange for you to protect our rights, protect our property, yada yada. You get what I'm saying? Yada yada yada. All right. Protection to person and property is the duty of government. And a government which knowingly and persistently denies or withholds from the governed such protection, when within its power, releases them from the obligation of obedience. That is equity. That's equity. That's equity. That makes perfect sense to me. See Georgia Constitution of 1877. So it's probably in the older Georgia Constitution. I don't care if it's still in there or not. That's a principle and it applies everywhere. Now let's get to it. All right, we got Washington right here. Our state constitution sets forth the blueprint for the structure of our state government. Central to that structure is the sovereignty of the people of the state of Washington. Central to that structure is the sovereignty of the people of the state of Washington. We don't have a democratic republic, all right? We have a republic. Now, if you're living in a city that has been converted into a territory of the legislature, that's the democracy, and that's why they saying democratic republic. That's the democracy. Central to that structure is the sovereignty of the people of the state of Washington, because all political power is inherent in the people, and governments derive their just powers from the consent, from the assent, from the agreement, of the governed, and are established to protect and maintain individual rights, private rights, protect private rights, fundamental rights. The people of the state are sovereign. There's the case citation right here. If you don't think I'm lying, if you don't believe me, this is the case citation. Go and read it. All right, that was the so-called state of Washington. Now let's go to the territory that belongs to the United States of America and does business on behalf of the United States of America by the name United States, and see what they say. I think there's about 3 or 4 different definitions for the words United States, just to let y'all know. The people adopted the 11th Amendment to nullify the Supreme Court's holding in Chisholm versus Georgia. That was the case where the Supreme Court essentially held that basically the people were sovereign and that they can sue the state in a court, in a federal court or whatever. All right. The people adopted the 11th Amendment to nullify the Supreme Court's holding in Chisholm versus Georgia. This might go over some of y'all head. The people adopted the 11th Amendment to nullify the Supreme Court's holding in Chisholm versus Georgia. I'm going to get back to that in a second. Yet the underlying principles of the Constitution, as explained by the Supreme Court, remain unchanged. The people, not their governments, are sovereign. This is the case right here that holds that. All right. Now, what does this mean right here? The people adopted the 11th Amendment to nullify the Supreme Court's holding in Chisholm versus Georgia. What does this mean? This means that the people can nullify at will every Supreme Court decision that they don't like by proposing an amendment to their Constitution. So if you don't want, if you want to list qualifications for so-called judges to be entitled to immunity, and when they're not entitled to immunity, if you want to prescribe that in your state constitution, you can do that. It's pretty much, the people have extremely broad authority as to what that they can put into their state constitution. I'm telling you what I know, not what I think, because the Constitution belongs to the people. It's a trust. Let's go down. This is Missouri. All right. In Missouri, the people are sovereign. The immunity is theirs. Not only the immunity is theirs, the judicial power is theirs. The legislative power is theirs. The executive power is theirs. It belongs to the people. By adoption of our Constitution, the people of Missouri assented to be governed and established the terms of the grant. Assented, agreed, consented. So if you can assent to be governed, consent to be a governor, or agree to be governed, then why you can't challenge their jurisdiction in these so-called courts? Because you can. And I've read plenty of cases that pretty much say that. They explicitly say that, by the way. There's the case right there, if you think I'm lying. Let's go down. What we got? Okay, we're in Virginia right now. Let's see what they say in Virginia. Under our system of government, the people are sovereign. See U.S. Constitution. We the people establish the Constitution. See Virginia Constitution, Article 1, Section 2. That all power is vested in and consequently derived from the people. The magistrates are their trustees and servants, and at all times amenable to them. What do they mean by magistrates? Magistrates is another word for public servants, because they're all public servants. They are all magistrates. That's what it means. Go to another Virginia case. The legislature is not sovereign. The people are the only sovereign, and an unconstitutional law is a violation of the sovereign will of the people. There's the case right there. But I'm crazy. We crazy, though. We crazy. Of course, you can't do what you want to do, all right, because you have to be held accountable for that. So you can't do what you want to do, all right. I'm gonna hold off on that comment right there. I'm gonna save it for another. It's gonna be in this video, but it's gonna be for another case citation that I read. All right, so this is New York. All right. While it is true that the holding in what is that? Cantillon versus McClellan, to the effect that as to the immunity from self-incrimination, the Constitution of the United States did not apply, has been overruled by the holding in Malloy versus Hogan. In all other respects, the decision still stands and is good law. At page 170 of the court's opinion, yada yada yada. Let me read you the case. I mean the merits, not the merits, but the holding. Suffice it to point out that we are dealing with a sovereign act of a sovereign people. The people of the state may write such provisions in their constitution as they see fit. The people of the state may write such provisions in their constitution as they see fit. Just letting y'all know, this is a principle. So even though this is a New York case, this is a principle, which means this applies to every country within this so-called country. I know that's confusing. So we're going to say this applies to every state. We'll do it like that, because even though states are countries. But we're going to say state just so I don't confuse anybody. One more time. The people of the state may write such provisions in their constitution as they see fit, without let or hindrance, which means without restriction. You can't without being hindered, stopped from doing it, without permission. We don't need your permission to do that. Without obstruction. See what I'm saying? That's what it means. Subject only. Now these are cases decided after, I believe, after they formed the union. All right. That's why I said subject only to the application. I'm sorry, to the applicable portions of the Constitution of the United States. The people in their new Constitution, pay attention to this, y'all. The people in their new Constitution could have abolished any or every public office in the state. The people in their new Constitution could have abolished any or every public office in the state, or changed the tenure of any public office. Public officers are the servants of the people, and the latter may say upon what terms. When they say latter, they mean, and the people may say upon what terms they shall be engaged or continue in office after their engagement. Later in its opinion, at page 171, the court said the people could provide in a constitution that no one should hold public office who had ever refused to sign a waiver of immunity. They have the power by a constitution to set conditions, with which there must be compliance, or if one is to be or continue to be a public officer. Immunity may still be claimed, but if claimed, one may not continue as a public officer. Is this making sense to y'all? Because it makes perfect sense to me. Alabama. That all political power is inherent in the people, and all free governments are founded on their authority. On whose authority? The people's authority. And instituted for their benefit. Whose benefit? The people's benefit. And that, therefore, they have at all times an inalienable and indefeasible right to change their form of government in any such manner as they may deem expedient. That means if you reasonably suspect that your public servants have become tyrants, and you've tried to do this the nice way, to where there's no violence or no war or whatever, and they just say, whatever, we're going to do what we want to do. That means If you want to get violent with them, then you have every right to do so. Because this doesn't belong to them. They're public servants. Let's go on down to the next case in Alabama. This case is based on State ex rel, Winter versus Sayer, yada, yada, yada. I'm going to read this for people who say statutes are laws, because statutes are not laws. So pay attention to this. The system is in itself and of itself complete. And although there has been a grant or reservation to the General Assembly, meaning the legislature, of power to establish inferior courts, we ain't going to call them inferior courts, we're going to say to establish administrative agencies of law and equity, there has not been any part or any fraction or fragment of judicial power left in abeyance, awaiting the happening of any future event, or the exercise of future legislative power to vitalize or quicken into activity. If the General Assembly never exercised the power to establish administrative agencies with which it was cloth, and its exercise is purely a matter of legislative discretion, the whole element of sovereignty known as the judicial power would still exist, confined to tribunals, which may properly be said to be of constitutional creation. So what this is saying is, even if the legislature never created any statutes in Alabama, even if the legislature never created any inferior courts, aka administrative agencies in Alabama, there would still be courts in Alabama. There would still be law in Alabama. Just to let y'all know, this is a principle, by the way. This is a principle because the people are sovereign. So what this is also saying is, it doesn't matter if the legislature creates courts or not, because the people have created their own courts in their constitution called superior courts, aka courts of general jurisdiction. I'm going to show y'all what I'm talking about in a minute. The people are sovereign. There's the case right there to hold that. Now let me show y'all what I'm talking about these so-called courts. There's another case in Alabama. Perkins versus Corbin. I did this on my YouTube channel. It was said in the case of Perkins versus Corbin, 45 Alabama, 102, at page 118. But aside from this objection to the petitioner's claim, the courts of this state are not only divided into courts superior, meaning general, superior, meaning general, and inferior, meaning limited. They are of different characters. Some are established by the Constitution itself, that is, by the people. They do not depend on legislative enactment for existence. They are created at the same time and in the same way with the legislature itself. They are of the same grade in sovereign power. They are a constituent branch of the government itself. The government under the Constitution is not complete without them. Did you hear that? Did y'all? Let me go back, because this might be going over some of y'all head. Might be going over some of y'all head, but it's not going over my head. And I just told y'all up here, right up here, that inferior courts or legislative courts, the system is complete without them up here. But the system is not complete without courts of general jurisdiction, aka superior courts. This is what they mean when they say this right here. The government under the Constitution is not complete without them. Are you paying attention to that? These are courts of general jurisdiction. These are the people's courts. The government is not complete without the people's courts. The government is complete without the legislative courts. Doesn't matter if they created courts or not. It doesn't matter if the legislature ever enacted any statute, because the system still is complete, because there is still law. The common law. You're going to be governed by common law and equity. That's what you're going to be governed by. Those are God's laws. These are the Senate sitting as a court of impeachment. Notice, y'all, that they're saying these are the Senate sitting at a court of, the Senate is sitting as a court, which is an administrative hearing. That's an administrative hearing, by the way, just to let y'all know. The Supreme Court, the circuit courts, the chancery courts, and the courts of probate. Now, this is an old case, okay? This is from 18, let me see, hold on. I have to go down here and look. It'll give it to me in a minute. But anyway, let's focus. Let's get back to it. These courts, meaning courts of general jurisdiction created by the sovereign people of Alabama, do not owe their existence to the legislative power, and the legislature cannot dispense with them or abolish them. Why they can't do that? I just wonder why. Because the legislature did not create them. They are emphatically the people's courts, and they proceed directly from the sovereign will. The sovereign will of who? The people. They constitute a coordinate and independent department of the government. And there is no other department of the government that can abolish them except for the people. The people are a coordinate department of the government. When the government is out of line, that's when you're supposed to step in and check them. The people alone, in whom is the ultimate sovereign power, can do this. They are each, in their way, constitutional elements of the state sovereignty itself as represented in the government. This is from 1952, okay. But they were citing an older case. All right. Here's another case in Alabama. Michael versus State, 1867. This is why you need to read the old cases. They just tell you what it is in the old cases. They don't care. No doubt, the ultimate sovereignty, meaning the power to the government making sovereignty, meaning the power to create government. Let me read that again. I'm sorry, y'all. No doubt, the ultimate sovereignty, the government making sovereignty, meaning the power to create a government, resides in the people. But after a government is once formed by the people, they, being the people, can only exercise this sovereignty, in other words, the power to create another government, by revolution, or in the manner they have prescribed to themselves in the Constitution. So let's say the people, sovereign people of Alabama, established them a government, and they want to abolish the government. They want to just do another government. They have two solutions in which they can do that. They can do it in a manner that they have prescribed to themselves in the Constitution, or they can start a revolution and create another government. The state in its corporate capacity is the people, limiting their conduct by the Constitution. All right. This video is probably going to be about 35 minutes, something like that. I'm going to try to keep it short, y'all. Arizona. Respondent also contends that certain statutes support her contention, but it would be absurd to say that the legislature, which is a creature of the people through their constitution, whose constitution? The people's constitution, could enact a law which would take precedence over constitutional provisions enacted by the people themselves. The legislature can't do that because they're not sovereign. Every so-called branch of government, being the judicial, legislative, and executive, all three of those branches of governments are administrative agencies of the people. The law that they are administering is the Constitution. Where do we leave off? Okay. This court will not violate the people's trust by attempting to subvert their constitution to any legislative enactment, because the court can't do that. He's a trustee. He's a magistrate. He can't do that. In the State versus Osborne, Arizona, this court stated, I think this is one with that long citation. No, that ain't it. All right. It's going to be the next one. But anyway, the legislature are but representatives delegated to perform duties in subordination to the will of the people. The legislature speaks for the people. The sovereign people speak in the language of their constitution. Their will, expressed in the Constitution, is the will of the sovereign itself. The legislature may speak, but only within the limitations of the fundamental law. What fundamental law? The Constitution. The courts may interpret and administer the law, but only in keeping with the oath of the judges to support the Constitution. The executive may execute the law, but under the guise of its execution, may not lay a hand against the sovereign will. Nobody can. This is why you need to know what your rights are. This is why you need to study law so you can understand what these people are doing. There's the case citation right there if you wanted it. Let's see. It's another Arizona case. Both our state and federal governments are constructed upon the principles of separation of powers into three equal and coordinate branches. For any one of these to police or supervise the operations of the others strikes at the very heart and core of the entire structure. Abuses within the reserved sphere of any of these branches of government may arise, but that fact does not give license to one of the coordinate branches to correct. Correction comes from within that branch, or how else? Correction comes from within that branch itself, or from the people to whom all public officers are responsible for their acts. All political power is inherent in the people, and governments derive their just powers from the consent of the governed. This is not a mere metaphor that sounds pleasing to the ear, nor is it a maxim that may not have a concrete application, but it is a vital principle adhered to in the formation of the government of this state. Let's go down again. There's one of them. It's a long citation. I'm going to read it because I'll be trying to make y'all understand this stuff. Federal and state governmental bodies, almost without exception, have the means with which to misuse their authority. But the safeguard and protection in our democracy, we don't have a democracy, we have a republic. But anyway, 1 second, y'all, I'll be right back. But the safeguard and protection in our democracy is more than equal to any such risk. We, in positions of governmental authority and responsibility, are there as representatives of the people. They are placed in these positions by the people and can be recalled by them. It is so to the people that they must at all times answer. There is nothing more easy than to imagine 1,000 tyrannical things which the legislature may do if its members forget all their duties, disregard the obligations they owe to their constituents, and recklessly determine to trample upon right and justice. Finally, even if the law were one without safeguards and the threat of abuse seemed imminent, this court has neither the power nor authority to decide upon the desirability of the measure. We are confined solely to the question of its constitutionality. That's it. The judiciary can only arrest the execution of a statute when it conflicts with the Constitution. It cannot run a race of opinions upon points of right, reason, and expediency with the lawmaking power. The courts are not the guardians of the rights of the people of the state, except as those rights are secured by some constitutional provision which comes within the judicial cognizance. The protection against unwise or oppressive legislation within constitutional bounds is by an appeal to the justice and patriotism of the representatives of the people. If this fail, the people in their sovereign capacity can correct the evil, but courts cannot assume their rights. There's Cooley again right there, y'all. There it is right there. This is in Arizona. There's Cooley again right there. Arkansas. I think I found a case that is citing this in Arkansas. The same thing. They're citing Cooley, if I'm not mistaken, Arkansas. In the case of State versus Donahue, I think, Arkansas is at 106, Arkansas 61. Mr. Justice Kirby, speaking for the court, said, "The people are the source of all political power, and it has never been doubted that, according to the institutions of this country, the sovereignty of every state resides in the people of the state, and they can alter or change their form of government at their own pleasure," meaning they don't have to wait every 5 or 6 years for a constitutional amendment. Whether they have done so is a question to be settled by the political power, and when that power has decided, the judiciary can but follow and sustain its action. That's all they can do. They can't do nothing else. Our right of self-government, a government by the people and for the people, is directly dependent upon our duty to defend our Constitution. One of the first cases published in our state explained the correlation between keeping our constitutional principles inviolate and maintaining our independence for the common good. Okay, this is that long one right here. An American Constitution, according to the theory and practice of our peculiar system, is the supreme, original, and written will of the people, acting in their highest sovereign capacity, creating and organizing the form of government, assigning to different departments their respective powers and duties, and restraining each and all of them within their own proper and peculiar sphere. The powers with which conferred, the restrictions with which are imposed, the authorities which are exercised, and the organization and distribution of them are all intended for the common benefit, and they are as essential to the maintenance and security of the entire plan as they are to the protection and preservation of liberty itself. Let's go down a little bit more. The principles which are thus declared by the sovereign will must of necessity remain inviolate and fundamental so long as the form of government under which they are established exists, or written constitutions with at all their boasted excellencies, or mere idle ceremonies or useless inventions. To deny their sovereignty and inviolability is at once to impeach the right of self-government and to destroy the only means by which that blessing can be perpetuated. The Constitution of the state is, then, the supreme, paramount law of the land, except if it comes into conflict with the Constitution of the United States or with the laws and treaties of the general government made in pursuance of its authority. And the courts are bound so to treat and consider it. We are not aware that this doctrine has ever been impugned or denied by any respectable authority since the decision in the case of Marbury versus Madison. Give me a second, y'all. I'm almost finished with this case citation. The Chief Justice of the United States Supreme Court then placed it upon such a high and unquestionable ground that since that time it never has been attempted to be shaken, and it is now universally acquiesced in and admitted by every intelligent man in the community. There is certainly a wide and striking difference between the Constitution of the United States and of a state government. The one is an enumeration and a delegation of certain specified powers granted by the states or the people of the states for national purposes and objects. Hence, Congress can exercise no power that is not specifically granted by the Constitution or incidentally included among some of its enumerated powers. By an inspection and examination of all the state constitutions of our own country, they will be found to be nothing more or less than so many bills of rights, declaratory of the great and essential principles of civil and political justice imposed as so many duties and enjoined as so many restrictions, but upon the departments of government and upon the people. I cannot ignore this duty. Our essential principles of civil and political justice depend on it. Accordingly, I dissent. Now, this was a dissenting opinion, but it doesn't matter if it was a dissenting opinion or not, because he listed principles, and these principles still apply today. All right, there's the case right there from Arkansas. All right. We're almost finished, y'all, so just bear with me. I'm sorry. Try not to make it so long. In Arkansas, the judiciary is a coordinate branch of government, and each branch is of equal dignity. It is not the function or within the power of this court to invade the constitutional authority of the legislature, a coordinate branch of our government. I'm going to be citing Cooley again right here. The courts are not the guardians of the rights of the people of the state, except as those rights are secured by some constitutional provision which comes within the judicial cognizance. The protection against unwise or oppressive legislation within constitutional bounds is by an appeal to the justice and patriotism of the representatives of the people. If this fails, the people in their sovereign capacity can correct the evil, but courts cannot assume their rights. The judiciary can only arrest the execution of a statute when it conflicts with the Constitution. It cannot run a race of opinions upon points of right, reason, and expediency with the lawmaking power. And there's the case right there, Arkansas, but they're citing Cooley again right there. See Cooley right there? Citing it again. All right, what else we got? Let's see what else. We got California. Okay, California. Under our political system of this country, the actual sovereign is the people, and all power of government and ownership of public property is invested in them and is to be exercised solely for their benefit. Whose benefit? The people's benefit. The state is but the organization, form of government, which the people have established for their protection, both as individuals and a body politic, with powers defined in a written constitution, and is sovereign only to the extent with which the people have invested it with their sovereignty. Being only a political entity, the powers and sovereignty thus conferred by the people must be exercised by individuals, and the exercise of the power under consideration has been instructed to the legislature. The legislature is, however, only the agent and representative of the people, and holds the power and sovereignty conferred upon it in trust, because the Constitution is a trust, that they shall be exercised in the interest and for the benefit of its constituents, and subordinate to the trust under which they are held. Let's go down a little bit more. As in the case of any other agent or trustee, an act done by it for the pure pose, and with the necessary result of injuring its principle of the people, or destroying the subject matter of the trust, even though done under the forms of authority conferred upon it, will be held ineffective. This is some 1897 California Supreme Court. We must, in any event, recall that it is ultimately the people of the state of California who are its highest sovereign power. California again, right there. This is a case from 2019. It's in Colorado. Colorado will be the last so-called state for this video. Okay. Here's the case citation right here. And here's the other one. These are two different case citations, but I'm going to give you this one right here from 1950. The people have the sovereign right to amend their constitution if they so desire, and the courts have no power to amend it for them. That is they like to do that when they issue so-called opinions. That's why Roe v. Wade was overturned, to be honest with y'all. Roe v. Wade was overturned because the judiciary exceeded its authority by taking power from the states. So essentially what they did was they returned that question of abortion back over to the states and let the states do it. That's what they did. The briefs point out that dangers may arise from unlimited proposals of amendments to the Constitution and seem to express a fear of abuse which the people may make which let me see something and seem to express a fear of the abuse which the people may make of their power. We have no right to assume such a result, and such argument, if heeded, would sweep away our present form of government. It is said in Section 1 of Article 2 of the Constitution that all political power is vested in and derived from the people, that all government of right originates from the people, is founded upon their will only, and is instituted solely for the good of the whole. Right there. What was that? Colorado. Yeah, from 1950. Here's the case citation, right? I'm sorry, y'all. I'm just getting a little discombobulated or whatever you want to call it. Now, this I copied this from this case right here. In any event, if the people chose to vote down a rate increase, that is their prerogative. They can do that. So I want to change this, and I'm just going to start adding stuff. In any event, if the people chose to list qualifications in which a judge was to be entitled to judicial immunity, that is their prerogative. They can do that. In any event, if the people chose to ban qualified immunity or change the standard of qualified immunity in which police officers argue to get immunity from violating their state constitution and federal constitution. So if the people wanted to change the qualifications in which police officers can be granted immunity, that is their prerogative. They can do that. What I'm trying to get y'all to understand is, generally speaking, the people's authority to add pretty much whatever they want in their constitution is extremely broad. Why do I say that? Because if you can make human trafficking lawful, then you can make anything lawful. Slavery was human trafficking. They had a right to slavery. It was in the Constitution. Give me a second, y'all. I'll be right back. All right, y'all, I'm back. Sorry about that. Okay, and then I'm going to do this one, and then that's going to be it. All political power is invested in and derived from the people. All government of right originates from the people. It is founded upon their will only and is instituted for the good of the whole. Yada, yada, yada. You get what I'm saying? So this was about probably, I think I did maybe 10 in this video. So what I'm going to do is I'm going to do 10 in each video, just showing y'all this stuff, because these people think we crazy. Like, they just start calling people crazy. Anyway, look, they're really just pissing me off with this. All right, and I'm just tired of it. That's why I'm doing a series of these videos. But anyway, I hope y'all enjoyed this video. There's another one I wanted to do, but I don't want this video to be too long. But it's a very good case. It's an Alabama case. So what I'll do is I'm going to pause the video and I'm going to show you the video that I already did on my YouTube channel. And if y'all want to check it out, you should go and check it out, because in that video, essentially it was the people's versus the legislature in that video, and they just flat out told you that the legislature is inferior to the people. They said the people are a coordinate branch of the government, and that the legislature is essentially inferior to the people. The people can take away the power from the legislature whenever they want. That's essentially what they said. But anyway, give me a second. Let me pause the video, and then we'll go ahead and wrap this video up. Be right back. All right, y'all, we back. So let me go ahead and wrap this up. All right, this video right here on my YouTube channel, it's called The People versus the Legislature. This video, I would advise y'all to go and watch this video. 17 minutes long. I'm reading the case. It's an Alabama Supreme Court case, but don't let that fool you, okay? That's a principle that is being discussed in that case, all right? So if you want to know what your rights are, you're going to have to read, all right? Y'all need to learn this stuff. That'll be the end of this video. The Supreme Litigant is out. Peace.